If you have a real product that's the core of your business, for example, you really want to spend the money to get this application drafted correctly. There's a potential pitfall with trademarks, and this is sort of now getting back to investors and what are the potential investors, what do they want to see? If you've gotten too far down the road and you haven't done a clearance search on your trademark name, and the potential investor sees that you haven't done a search, that's going to raise a red flag. Come up with a plan, make yourself more attractive to investors, lock down your IP.
Okay, welcome back to Seed Money. Today, we have got Ray DiPerna. Who is our IP legal expert, because this is such an important topic and most of us entrepreneurs don't have a clue when it comes to this stuff. So we are bringing in Ray today to talk about all things IP, how to protect yourself, your company, your products, all that good stuff. Ray, reading your background, I love it because grew up near Boston, as did I. Had 10 siblings, so no wonder you're drawn to startups and a little bit of craziness there. That's amazing. Lived in New York City for 25 years, went to law school, moved to San Diego, and now back in East Hampton. And I also lived in Solana Beach for 7 years, and I lived in Montauk for a short period. So anyway, we have some funny similarities there, but how are you doing today? And to start it off, tell us a little bit about your law firm and congrats on branching out and doing your own thing.
Sure. Thanks so much for the intro and thanks for having me on. As you said, I've been an IP lawyer for over 25 years. Started out in New York City, worked for 3 of the major IP boutique firms there. I was a partner at one of them for several years. And then one day, my wife and I decided we wanted to move to San Diego. So took a job at one of the big law firms over there, still, of course, in IP. And we were there a couple years or more, and now we're back. I wanted to start my own firm because I wanted to have more control over, choice of clients and choice of work and that sort of thing, and more autonomy over what I was doing. And I wanted to offer broader services to my clients. So really all facets of IP is what I handle. And, patents, I've been a patent lawyer 25 years on a daily basis. We do trademarks, copyrights, trade secrets, but also some data privacy work and building terms of use for websites for new businesses and just general counseling. So that's the background and started in July of 2023. So I'm sort of a startup. I don't need a lot of seed money to start a law firm. It's a few $1,000s. So it was easier from that front, but I have some of the experiences of certainly of startups.
Amazing. So I got to say, I had a couple law firms that were specialized in working with startups, and having that understanding, I can't even tell you how much they helped me and how thankful I was to have their advice and their expertise. So I think the fact that you do IP, but you are interested in the startup stage and you lean into that, for anybody who's looking for an IP attorney, somebody like that, like Ray, who does specialize in the startup space and in IP, is a really good fit because I think there are a lot of nuances when you're starting out and balancing, making sure you're fully protected without going overboard, or maybe you do need to, just making sure you're checking all the boxes you need to line yourself up for future funding, eliminating risk and making sure you maximize the value of your company as well. So Ray sent over an amazing outline here, which I think is incredible. And I think we're going to structure this a little bit more just like a workshop, because you've got all the nuts and bolts here. And then there's some other topics that you mentioned that I think are important. But just to start off with, let's go through, general IP, patents and inventions, trademarks and branding, and trade secrets. And what I'm going to do, because obviously that's not relevant to everybody, but we'll timestamp it below. So, if you're currently doing a patent, you can go directly to that part if you're not focused on a trademark, that kind of thing. But Ray, I'm going to let you kind of run with it and kind of work off your outline there, because I think you've mapped it out very clearly and in an organized way to kind of present on the show. So yeah, let's start off with, what is IP for your very basic, entrepreneur who might just be starting or has an idea? Why should entrepreneurs and startups be thinking about IP, and what value does it have?
Sure. Well, it's something that a lot of people are not familiar with, in all its detail, of course. And why would they be? Because, it takes years of experience to really learn this. But it's something that startups and entrepreneurs should be thinking of right from the jump. Because if they don't think about it right away, and some of them may say, well, let me wait and I'll scale up my business and then I'll focus on the IP. That can be a big mistake, because you could lose IP rights that you otherwise had. You could be infringing unwittingly. You could be infringing other people's IP rights. And so that's a big problem if it happens for a business, and it certainly doesn't attract you well to potential investors. So IP has a lot of value, as we'll talk about, and we'll talk about the different forms. But this is something I want to stress. Startups should be thinking about right from the beginning stages. Yeah.
Okay. Yeah, I think that's an important point. If people are going to give you money, investors, they want to know that, what they're investing in is protected and also not going to get sued because it's infringing on someone else's IP, which is a really important point you just made. So let's start off talking about patents and inventions. How does a startup identify and kind of protect something that is patentable?
Right. So the first step there is to identify what is a patent and whether you have patentable subject matter. There's different forms of IP. The value in IP is that you can create barriers to entry of people coming into your space. You don't want them to copy what you're doing. You can create a competitive advantage. And so if you have a patent, an invention that's protected by a patent, that's certainly important to think about. If you have branding that you want to protect by trademarks, a business name, a product name, a service name, something like that, that's certainly something to think about. And then there are various other forms such as trade secrets and copyrights. But as to the patents, maybe you have a startup and you're offering this great product or service to people. You might have something that's patentable there. And you certainly need, but not all startups will have something that's patentable, but all startups should ask themselves if they do, and should ask an attorney if they do. Basically, if you have a product or service or method or even a software platform, something like that could be patentable. The touchstones of patentability are that it has to be new, like novel, and not obvious from what came before, and it has to be something that is what we call patent eligible subject matter. So typically that's, an apparatus, a device, a method, some sort of a process. And there's a lot there in the eligibility box, but that is sort of the opening question that startups have to be thinking about, because it's very important. If you don't think about this at the beginning and you have a patentable invention, as soon as you publish it, like disclose it to the public, maybe that's through a website, maybe that's through a trade show, something like that. As soon as you disclose that to the public, you've started a clock running in the United States. You have 1 year from that period to file a patent application, or you'll lose your rights in the invention. In foreign countries and jurisdictions, it's not so forgiving. You don't have the 1 year grace period. You could be time barred right from public disclosure of filing a patent application. So this is one of the things where we talked about earlier, where startups have to be thinking about this from the jump. If they don't, they could blow through one of these deadlines, and they might have something that's really valuable as a patent, but not be able to protect it because they haven't been paying attention to the deadlines.
I totally forgot about that. I had heard that before. I've never patented anything. I've mostly done like trademark stuff. That's very important. And in terms of patents, so basically you can patent, processes, right? Software, functionality in a product. if someone has, say, a footwear brand and a unique material, something like that can be patented. I came from the food and beverage space, and I think this came up a lot in, how to protect recipes and stuff like that. If my understanding is if there's a process that's unique in your recipe, maybe that could be patented, but obviously you can't patent a recipe itself. That's more of a trade secret thing. What are, could you speak to that a little bit in terms of some of the things that might be like a component of your product that could be patented, and it's worth consulting with an attorney to say, here's everything I'm doing. Is any portion of this, patentable?
Sure. I mean, you could have a lot of the food companies have patents. You could have a patent on a component of a product. You could have a patent on a process for making the product. Something like the recipe could be something that falls more, as you mentioned, Jayla, into a trade secret. The famous one is the Coca-Cola formula, right? And they've worked so hard to protect that over decades. And they don't want that to fall into the wrong hands. It's funny with trade secrets because you can reverse engineer a trade secret and be okay. If I came up with the Coke formula independently, I can go ahead and make Coke make the product. Whereas if they would have a patent on that, they don't, because patents terms are 20 years and there's different reasons we can go into it. But if someone has a patent on something, then even if I come up to it independently, I am not able to copy the invention. So patents are important because they provide a bundle of exclusive rights. So you can exclude others from making, using, selling, offering for sale, or importing into the United States if we're talking about a US patent. The subject matter that's covered by your invention. And so with those exclusive rights, you can really carve out a space for yourself if you have an important product or service that is protected by patent, and others are not entitled to come into your space. If they do, there are certain measures that you can take. But that's the value of a patent. And you can license a patent, you can sell a patent. The value is it's covering your product that you're making, and you prevent other people from coming in, as I said. Investors look for this. They look to see if you have any patentable inventions in your sort of portfolio. They want to see that you've thought about this subject, that if you have anything patentable, that you have taken steps to either keep it secret until you file it, or you've taken steps to file and then you've preserved foreign rights. They also want to see that ownership is something that you've thought about, so that if you have employees that are creating patentable inventions, or consultants or third parties, you want to be sure you have agreements in place that anything that they create or invent is owned by the company. So this is very important. Potential investors want to see it. They also want to see what your patent application looks like if you filed it. Is it something that's just like a chicken scratch thing on the back of a napkin, is 2 pages long, or is it something that you've had an attorney put a lot of thought and substance into? Patents are not the same as trademarks or copyrights in the sense that a patent application is very substantive, and it's 10 or 20 or 50 pages long, and it's got diagrams and different embodiments. And that's why it costs, $10,000 to $15,000 for an attorney to produce this document, speaking to your engineers and so forth. But this is something that investors do want to look for, and they watch for.
Couple questions around that. So you mentioned $10,000 to $15,000 to get the whole patent. What is to kick off the patent process and basically be able to go into it with patent pending, which I think is you're somewhat protected at that point, if I'm correct. What is, again, if someone's going out to raise money, can they get to that patent pending spot for less than 10 to 15,000, or is it really that's kind of the minimum you're looking at, even just to get to patent pending and then waiting for it to go all the way through?
These are great questions. Take it in turn. 10 to 15,000 is probably the money, the service fees that you'll pay to the attorney for drafting. And you could probably get the patent application on file for that price. I mean, I'm giving generalities. There are different circumstances, but they cost, around that to get on file. And then later you're going to have costs as you get examination reports and so forth. And you're going to have costs to deal with examination reports and respond to what we call office actions. So your second question was, can you reduce that cost in some way? There is something called a provisional patent application. That's sort of a preliminary application. And you don't have to file as much nuts and bolts into the provisional application. You can try to save some of your costs off. And you can certainly do it. You can file just an inventor's disclosure document as is, almost as a provisional application. The problem is, if you don't put some thought into it at the beginning, then you could run into the problem where your document that you file is not protecting you as much as it could. So you've got the basics of the invention down, but maybe there are different embodiments that aren't being protected and so forth. So this is a technique that a lot of applicants use, and it's a good one. You just have to sort of weigh cost versus the benefit of the utility of the provisional application that you're filing. But there are strategies that the attorney can work with you to try to keep costs low, but also get something on file that's weighty. But at the end of the day, if you really want to do this right, if you have a real product that's the core of your business, for example, you really want to spend the money to get this application drafted correctly. I want to make one more comment about patent pending. Patent pending is something that a lot of startups and entrepreneurs do know about. They're anxious to get patent pending. And it's good to have it because it shows the world, and particular potential investors, that you think you have an invention that's patentable and that you filed a patent application on it. You're not allowed to put patent pending unless you have a patent application on file. But once you do, you can put it. But there's no real legal effect to those words other than that. So someone looking at patent pending will probably say, okay, they're pretty serious, but they're not going to know what the quality of the patent application is. Is it a 2-pager or is it 10 pages? What's the substance of it? So it does have some benefits as far as, investors maybe like to see it. But investors are going to do their own due diligence and they're going to want to see under a non-disclosure agreement what actually you have filed in that regard. And I'll make one more point about what investors like to see and public, because I mentioned before, if you disclose your application or your invention publicly, you could be time barred from filing it. Well, you're allowed to show it to third parties or potential investors under a non-disclosure agreement, and that's not considered public use. So you can preserve your right to file in the U.S. or foreign countries if if you pay close attention to NDAs.
Got it. Okay. That brings up a really good point around NDAs, I think. A lot of investors don't want to sign NDAs because they're looking at tons of companies, right, all the time. My perspective on that was always, look, it takes a lot of time and effort to actually bring a product to market. And the chances of someone knocking you off, are they really going to do that? If a bigger company is going to knock it off, it is what it is. I don't know. So I was in the camp of just, I'm going to put it out there to as many people as I can because that's how I'm going to get the funding. What's your advice on balancing and especially if there is something more technical that could be let out of the bag and somebody could quote unquote steal? What's your advice on approaching an investor with an NDA in exchange for really viewing that paperwork, that patent? Do you think it really is critical to get the NDA? I don't know, just any thoughts or advice on that? Because that can be a tricky one sometimes.
Yeah, I mean, you can play with this in various ways. Like maybe if they're not going to sign an NDA, I wouldn't show them the whole invention. I wouldn't show them how it works, like the nuts and bolts of it. I'd show them maybe some advantages of it, maybe some overall aspects of it. But if you're going to show the nuts and bolts of how something works or how you make and use something, if you don't do it under an NDA, then you're going to run the risk of losing foreign rights right away. Now, I mentioned the 1-year time period for the U.S. You could still potentially, file in the United States within a year, and that's not going to destroy your patent rights. But then there's the question of you're not protected and you're showing certain things to people, and are they going to be unscrupulous and try to steal them? So you always have to be aware of that. And balance the risks and rewards. If they won't sign an NDA, which many of them won't, because they don't want to be obligated that you're going to come back and sue them later when they didn't really do anything wrong. That's their fear of filing, signing one. It's not so much that they're intending on stealing the invention, but they don't want to be on the hook for this NDA. Just show them some like overall aspects and bare bones things and not the whole thing.
Got it. Okay, great advice. For those listeners who've already filed the patent paperwork, maybe they have the patent pending or they even have their patents. I think this happens to a lot of entrepreneurs. It's like, I filed the paperwork, check that box, and now I'm off focused on a million other things. And a year goes by and I forget to do the next thing or on time. What do you recommend, or what are some of the mistakes that you see entrepreneurs make maybe after they file that initial patent paperwork? Or is it just, make sure your attorney is kind of following up with you and pushing the steps along? I don't know. Are there any mistakes there where they could drop the ball potentially, and risk their IP?
Sure. I mean, if you're filing things without an attorney, that's where the real risk comes, because then there are a lot of certain deadlines that you have to be aware of that you may not be aware of. You may not document them right, et cetera. Like, for example, the provisional patent application I filed, you have 1 year from that point to file a a full-blown patent application. And if you don't, you can lose. You're going to lose your rights, or at least you'll lose your priority date in a provisional application, because those are kept secret. So if you are using an attorney, the attorney really should and must and will keep track of these deadlines. I do it. We have docketing software. We keep track of it ourselves. We make sure that we're advising clients properly, because if we don't do it, then we're on the hook for malpractice. Because these deadlines are important, especially the 1 year deadline for foreign filing. And so, I mentioned, just to be clear, I mentioned now a 1 year deadline, where before I said, immediately after public disclosure, you could lose foreign rights. Well, it turns out if you file a patent application anywhere in the world, that acts as a nice placeholder. So if I file in the United States first, I have 1 year from there to go into foreign countries. So I don't have to decide, oh my God, I got to go into Japan right now and China right now and so forth. I have a year, and then there's ways to prolong that year period. But these are dates that the attorney will keep in mind and will advise you of. So you don't have to really worry that you're going to blow past those if you're with an attorney, hopefully.
Got it. Okay. And I think that's a good point. All of this stuff is very complex. Everybody's situation is a little bit different. You're giving us a really great overview, but obviously that is why you need to consult with an attorney on your specific situation, just to, make sure you're, because there are a lot of little nuances here. Okay, let's talk about, here's one more question. What are potential investors looking for in patents? Are there any specific nuances there that they are looking for in a patent? Like, what is a better quality patent over another? I don't know if that's a thing or not, but anything along those lines.
I mean, if they're sophisticated, they're going to, as I said, do a due diligence, and they're going to have their own attorneys inspect the patent application to understand what the scope of coverage is there and exactly what the invention is directed to. Again, it depends on how much you show them, as we discussed. But they are looking for something of substance there. They're looking for the fact that any inventors are obligated to assign that over to the company that writes in the invention. And they're looking to make sure that foreign filing deadlines have not been missed, especially if this is an invention that is ripe for foreign filing. And why do you foreign file? Because the U.S. patent only covers U.S. territory. Maybe you're producing or manufacturing the invention overseas. Maybe you want to license it overseas. Maybe you want to enforce it overseas. You can't do that unless you have filed overseas. But I should make a note as to cost. I mean, nobody can file in 1,000 countries. You have to be very circumspect about which foreign jurisdictions you go into, if any. A lot of applicants choose not to, just because it's more cost. And each patent application there could be, tens of thousands of dollars to file and prosecute in all these different countries, certainly. So you have to be a little bit circumspect in where you file.
And is that something you can help provide advice on, or is that just basic market research? Or can you look at other countries and say, hey, we recommend for this product space filing in these countries or, anything like that? Or is that more hey, we're going to get the funding and then we're going to, figure out what our game plan is? And
Sure. Yeah. No, it's a great question, Jayla, because, well, there's two things here. One is the attorney is going to ask questions about where are you manufacturing? Where do you think that the people are going to, which countries do you think would actually be using this invention? Um, the second part of that is there are certain types of patents, particularly relating to software, that are more patentable in the United States than in Europe, for example. Software is a big one. I mean, software has gone for decades through a lot of case law as to whether software can be patented, more particularly like how to patent it. And I won't run through the whole thing because we could be here for hours. But there was a 2014 Supreme Court decision. The Supreme Court is funny because they don't always get involved in patent matters. It's not really a real political thing, and usually every few years, a really important Supreme Court case comes up in patents. Usually we're dealing with the federal circuit, the lower courts, but they ruled, the Supreme Court in 2014 in a case called CLS v. Alice Bank, that in order to get a patent on software or on any business method or on AI, you need to be really solving a technical problem, which is like a technical solution to a technical problem, if I'm going to boil it down. So that's like a computer problem, making a computer function faster or more memory space or something like that. And so the point I want to make is that if your invention is merely automating a manual process, let's say you have this great method of investing in stocks, right? And you want to put it on a software platform, and then that's going to be your product. You're probably not going to be able to patent that because it's just really automating what is being done in your head. There's a mental steps doctrine where if you're doing something in your head, like I can teach a method of doing exercise, right? And that's all coming from my head and I'm putting it on a computer. It's not going to result in a patent. So I'm being really broad. I'm giving a really overview, like a bird's eye summary, and it all depends on the details. I don't want to tell you you can't get a patent on this or that. I wouldn't be able to know until I looked at what you have. But that's the basic point of it. And then so if you go into Europe and you're trying to patent like something that you got a software patent in the US, you may not be able to patent it there. So that's why a lot of applicants with software inventions shy away from Europe, for example.
Oh, interesting. Okay, yeah. I didn't know that. Okay, super helpful. Let's go into trademarks and branding. This was kind of more my space, and I am definitely along the lines of like hire an attorney to do it because technically you can file your own trademark, but bad idea. So what should a startup file? What kind of things should they trademark? Deadlines, requirements. Talk to us a little bit about trademarks and branding.
Sure. So if you think of a brand, so trademarks start with branding. Like a brand is sort of a identity of the company, the fabric of the company, how customers perceive your company and your brand. Like let's take Nike as an example. They have that swoosh logo, they have Nike, they have like slogans like just do it. And they're backed by, famous athletes. I mean, I assume LeBron James does Nike. It's sort of off the top of my head. I'm not sure if he does, but a lot of famous athletes and well-respected athletes come in and they endorse products for their brand. So they have created a whole brand around, excellence and excelling and motivating and just do it and so forth. And that's their brand. And how are they going to protect their brand? They're going to protect it through trademarks as one form. Nike, the slogan, just do it, can be trademarked. So a trademark is sort of a slogan, a logo, a business name, a product name, something that you're using in commerce. And, you're selling T-shirts with Nike on it. That's, of course, what I mean by in commerce. And it's something that is going to operate to carve out a little space for you so that if you have Nike, someone else can't come along and try to produce Nike T-shirts without your approval. And so trademarks turn on, it's easier to get a mark that we call fanciful or arbitrary than a generic mark. So if you're trying to get a trademark on pizza, it's not going to work. If there's a sort of a sliding scale up from generic to descriptive to suggestive to arbitrary and then fanciful. But a fanciful example, I think, is Pepsi. I think they made that name up themselves. And so if you make up a name, you're much more likely to be able to get a trademark than if you're going with, obviously, pizza or a more generic sounding name. Apple, for example, you wouldn't probably be able to get a trademark on apples, but you can get a trademark on Apple computers because it's arbitrary to computers. So that's a big thing to think about, is what is your branding going to be, and how am I choosing the branding? Am I likely to get trademark protection on it? And so when you file a trademark application, the examiner will do a search and will say, okay, your mark is X and it's maybe similar to these other marks, and it's important what goods and services you're trying to protect in. I think there's Delta Airlines and then there's Delta Faucets, and it's totally different, right? So if you're in a different area of goods and services, you may be able to get the same name as another company. It all turns on likelihood of confusion. So would a customer looking at, let's just use an example, Coca-Cola versus Coca-Cola. I've been living under a rock, and I don't know that there's Coca-Cola, and I've come up with Coca-Cola, and I'm going to try to get a trademark on that to produce soft drinks. I'm not going to get very far along the line before Coca-Cola pops its head up and says, wait a minute, you're infringing our brand. Please stop doing this. And so there's a couple of points here, which is, one, would a customer likely be confused buying my Coca-Cola thinking they're really purchasing something that comes from Coca-Cola? So it's all about sourcing, and what is the source of the goods, and how are you distinguishing your goods or branding from someone else's? And that's what trademarks do. There's a potential pitfall with trademarks. And this is sort of now getting back to investors, and what are the potential investors? What do they want to see? They want to see that you've thought about branding and a trademark strategy. It's not so critical to file a trademark registration right away. There are certain common law rights. Trademark rights stem from use. And the moment you start using a trademark, you could have certain common law rights. You're probably going to want to file federally pretty quickly, because you want to get nationwide rights rather than just like limited to a specific geographic area. And then you get various other benefits with federal filing. You can enforce it in federal court, et cetera. But the potential investors are going to want to see that you've thought about this, and that, that you've done a clearance search, because it's very important to do due diligence on this. Maybe you can wait a little bit to file for a federal registration. It's very cheap compared to patents, so maybe you don't have to wait. But if you've gotten too far down the road and you haven't done a clearance search on your trademark name, and the potential investor sees that you haven't done a search, that's going to raise a red flag, because it increases the risk to them of investing in your company. And what you don't want to do is go and spend all this money on marketing and branding and so forth, and get down the road with some sort of a trademark, and then someone pops their head up and says, no, I have this. And now you get your trademark attorney, you're costing more money, and he or she will look at the differences between what you have and what they have. And he or she may say, you've got to change your branding. The risks are too much. The money that you're going to outlay is too much. But now you've spent all this money on branding and marketing, and you have to go change everything. And that's why it's important to think about this right from the beginning, so you don't fall into this trap.
Yeah, I totally agree. And the nerd that I am, like, fun for me on a Friday is like going through the USPTO, I think it is, trademark website, and looking, and it is fun because you can see all the different trademarks and the classifications they're in. However, what I will say from experience, I've looked on there before, thought there was something available, and then I had my trademark attorney do their search, and they uncover things. So again, for the DIYers out there, yes, you can do a surface level search kind of on your own on some of the government websites, but you still really, especially if you're going to pitch investors and investing, like you just said, in time and branding and go-to-market strategy, to have to change that a couple of years in would be really bad if you get a cease and desist letter. So, you do want to get an attorney to do a thorough search there, because you guys are able to like find stuff, I think, that at least in my experience, that, your average person can't find.
Sure, that's exactly right. There's a certain art to searching. There's vendors that probably do it much better even than attorneys. The cost for a search is not so much. It might, depends on the different levels of searching you want to do. A preliminary one could cost $500, but if you want to do a more substantive one, a fuller search, as you said, which is recommended, you might only spend 1,000 or 1,500 for a search and analysis and to see what's out there. So it's not again like patents where you're spending 15,000 right off the bat. The costs are more modest, and they can save you a lot of trouble and headache later. Because if you get hit with a cease and desist letter, um, it may be that the company who owns the trademark is happy to see you just sort of go away. They can't sue everyone, right? And so a lot of times they pop up and then they send a cease and desist, and it's like, okay, we'll stop using this and so forth. And everyone sort of goes their separate ways. But sometimes that doesn't happen, and they're more aggressive, especially the bigger companies are more aggressive, or they think that you have unscrupulously, it wasn't an innocent mistake, and now you're diluting their brand or something like that. And they may sue you, which is a much bigger headache, of course. So it's hard to predict what a rights holder will do. So it's better to really get legal advice to try to stay out of these issues.
Yep. One more point kind of along those lines. You mentioned this in your outline and briefly before. Employees who maybe they're naming a new product line, and that product line name could infringe on someone else's trademark, right? So, and then also if an employee names the product and you do want to get that trademark, talk to us a little bit about maintaining IP under the company, even if it's an employee or contractor who comes up with the name or something like that. Like what kind of, issues pop up in those scenarios?
Sure. I mean, this is creative content, and who is behind it and creating, and actually the brains behind it is very important to think about, because if you are paying your employees a certain wage or salary or something, it's very typical for employees who work for a company to sign an agreement with the company that any IP that they create on the company time as part of their work, whether it's inventions or trademarks or branding, as you mentioned, is held by the company. So if you have that sort of assignment agreement in place, and you make sure that you tell the employees this, maybe it's a handbook, maybe it's a contract that they're signing, et cetera. It should really be a contract. Then the company is more protected and is not running the risk that the employee will go out and think that they have created this on their own. But this is the employees, especially those in media or sportscasters, they're always coming up with names for things, for new shows, for new product lines. And they always, there's often this tension between what the employer thinks that they own and what the employee thinks that he or she owns. And so if you have solid employment agreements from the jump, that's going to help you a lot as a startup.
Yeah, I think that's a really good point. Always have some sort of contract with an IP clause, even for all your contractors, anyone doing just side projects or anything like that. Great advice. Okay, so IP monetization. So talk to us a little bit about how does a startup or a company, kind of monetize their IP?
Right. It's a good thing to think about, because there are various ways to monetize IP, and IP can be incredibly valuable. So not only as we talked about, do you have an invention, for example, that's protecting some product, and then people can't come and copy it. They can't copy your branding, et cetera. That provides you with value just by the fact that you are producing this product, or you have this company with this branding, and is protecting what you're actually doing. And it also provides value because, as I said, potential investors will come in and look to see that this stuff is locked down. There's also a way to monetize IP if you assign your patent or trademark to another company, if you license it to another company or another party. That's another way to get a lot of revenue. You'll notice that Disney or Paramount, some of the big, huge companies, they have their own licensing, consumer licensing product lines, for example, or programs. So Disney will have a consumer products program where if you apply and you basically go to Disney and you ask them, hey, you're doing Mickey Mouse, can I put this on T-shirts? They may tell you no, they may tell you yes, but there's a lot to this. But the point is, these companies make a lot of money on these revenue streams, licensing their content. And if you want to be producing T-shirts with certain movie characters on it or something, they'll check quality control. The big licensors, they'll want to make sure that you're producing this in a way that's not going to tarnish their brand or hurt their brand. But that's a big way to get a revenue stream going is licensing your IP, selling your IP, and then of course enforcement is a big thing where someone might be infringing your IP and you have to bring an enforcement action in federal court or wherever. And that is something that you've probably seen some numbers from this, which is it could bring in a lot of money on the backside if you are successful in a judgment on that in that kind of a case.
What are the costs around litigation, like either defending kind of your own IP or going after somebody else? Any?
Well, it's an area that stuns people, even people sophisticated and for example, they work for years, a couple of years with the patent office or 3 years with their attorney and with the patent office, and they get a patent, and then they've spent a lot of money doing that, and they're shocked to learn that that is just the beginning of any enforcement process. It's a necessary first step, which is then they see that there are companies out there that are infringing their patent in their view. And they're shocked to see that in order to file a patent infringement lawsuit or even a trademark infringement lawsuit, it costs millions of dollars. It could cost $2, $3, $4, $5 million easily. And yes, and how are you as a startup going to fund that? It's a big question. But the first step in enforcement is let's send them a cease and desist. Let's see if they stop. A lot of parties receiving or companies receiving a cease and desist will decide to ignore it. They will decide that they don't infringe and they're not going to worry about this. Some of them will get back to you and say, look, thank you for your letter. We don't think we infringe. Some of them will think they infringe and will want sort of a license or something like that. But two things here. Number one, it's very important if you're on the receiving end of a cease and desist letter, and I say some companies may choose to ignore it, you don't ignore it without talking to an attorney because you could really be getting into trouble, racking up damages and infringement damages, and you're not even paying attention. Then you could get hit with willful treble damages for willful infringement. So don't ignore it. Go to the attorney. And if the attorney, I do this myself, I present options like you can ignore it and here's the risk. You can respond and here's the risk. You can license. So you get your options and then make a business decision about how you want to respond to this. Getting back to the cost of a litigation, because I mentioned it's 2, 3, 4 million easily sometimes for a patent or a trademark infringement. I mean, these lawyers, especially at the big firms, don't work cheap. They charge at the big firms $1,000 an hour, $1,200 an hour. Much more than the smaller firms would charge, which are around half that. But the point is, the person is shocked because now how am I going to enforce and file a lawsuit if I don't have the money to do it? You can get a litigation funder involved. Litigation funders are sort of entrepreneurial companies themselves. They look for good investment opportunities. It's an investment opportunity if someone has this great patent and there are infringers, especially some of the bigger companies are potential infringers. And the funder, and it happens often, but it's not like everyone can get a funder. They're very circumspect with what projects they take on. They'll do a due diligence first and make sure that your patent application, they'll go over with a fine-tooth comb and make sure that it's really a quality patent application that has a sort of broad coverage and that you can target and potentially succeed against an accused infringer. And then they'll want they're not going to, of course, fund a lawsuit for free. What they want is money in return. They're hoping that you win the lawsuit and they get certain money. So if it's, let's just use an example, $5 million that they commit to funding this lawsuit, they'll probably want to get the first 5 million back in any judgment. So if you get a $20 million judgment, they'll want to get the first five, and then there's what we call a waterfall, where they'll get a percentage of the remainder, and you'll get a percentage of the remainder, and things proceed that way. They see it as important investment opportunities for them. It allows you not to, let an accused infringer get off the hook. You get some benefit from it because you'll get some of the judgment, and you'll share the judgment, but you're not getting zero, which is an important consideration.
Yeah, that's very cool. I didn't realize that was a thing. I was talking to a guy who had a really cool patent on a product. He wanted to look at licensing it, but he was really nervous about, the bigger companies licensing it to just basically taking it and running with it. But that's a great option just to know. Would you recommend like someone like that talk to one of those firms ahead of time to see if their patent is strong enough to defend if one of their, licensees took the technology?
Yeah, I mean, these are all issues that should be worked out with an attorney, and the attorney is going to want to really analyze the facts. If you're talking about an employee that has stolen something, you have contracts and agreements in place, hopefully for that, and then there could be, a patent infringement lawsuit. Depending, it's very fact sensitive. But before sending out a cease and desist, an attorney is going to want to analyze the case. Make sure that they're not sending out a cease and desist letter that's sort of frivolous. You want to be able to, you don't want to put your reputation on the line as an attorney and just send out something even though you don't think that they're infringing. You need some sort of good faith basis in which to make some sort of accusation like this as an attorney on behalf of your client. But as far as stealing inventions or licensing, I mean, it's all very fact sensitive as to, what the agreements were, who had access to what did they do to it, or what did they do with the ideas, and et cetera. So these are also things that are protected potentially by trade secrets. A business may have secrets that are core to the business that the business doesn't want to let out. They may not be patentable, or maybe they are patentable, but you'd rather keep it a secret. These could be customer lists, client lists, phone numbers, engineering drawings, software programs, et cetera. And they want to keep it as a trade secret because as long as it has some business or economic value and you take reasonable steps to protect it, then you would have a case against an employee who, despite an employment agreement or whatnot, has gone out and misappropriated your trade secret, and you'd have a much better case against the employee if you've taken steps to keep it secret with NDAs, confidentiality agreements, employment agreements, et cetera. So all of this is fact sensitive, but they're all things, as you rightly note, that a business has to be thinking about.
Switch gears a tiny bit as it relates to people raising money and getting offers for people to find them investors for payment. And, I know enough, like I love making introductions to entrepreneurs, to investors, like, no, I don't expect anything. It's just fun for me to make those connections. But there are people out there who are, hey, I'll make these connections for you. I'll find you investors. You pay me a fee or give me a percentage of your company or something like that. What are the legal parameters or, pitfalls around that?
Yeah, I mean, it's a big area and it's a very sensitive area to the point where if you are engaging a finder to find a funder and you're going to pay the finder, you really want to run this by an attorney because especially if you're offering a percentage of your company or equity, because that brings up securities, and then the SEC is involved. So the big issue is whether the finder needs a broker-dealer license with the SEC or some of the other regulatory bodies in order to act as a finder. And if you are going to a finder and the person does not have a broker-dealer's license, you could be running serious risks. Not only the finder is running a risk, but you as a company and you as a personal liability are running a risk. So this is very fact sensitive. The law in this area in the SEC and the court decisions used to be a lot more forgiving to finders, but what it's coming down to is that if the finder is being paid a percentage based on the success of the funding, so the amount raised, and the finder is being paid a percentage of the amount raised, sort of a transaction-based fee. It's really the case that the finder is going to need a broker-dealer's license, and possibly if the finder is just making an introduction and getting out of the way, and then getting a flat fee, and they're not involved in analyzing the deal or negotiations or anything like that, any due diligence, it's possible they won't need a broker-dealer's license. But it's so risky that the general rule and the legal advice just lining on the side of just get the broker-dealer's license, but certainly consult an attorney to make sure that you go through the specific facts with the attorney, because, as I said, the law's gotten a lot more strict in this area, and the penalties are grave. I mean, you could be on the hook for substantial fines from the SEC, from federal bodies, from state bodies. You could be on the hook for personal liability, sort of piercing the veil, as we say. You could be on the hook where an agreement that you have with a potential investor or with the investor might be voidable. The investor may have the option to void the agreement if the finder didn't have a broker-dealer's license. So, yeah, so you can see, Jayla, that the risks of this are so great that it doesn't make sense to play with this. Consult an attorney is my advice.
And those are newer laws, I think, as you said, because I remember, I guess this was like 15 years ago, but did I pay? I think I did pay out like one finder's fee. I definitely had, quote unquote, agreements in place for finder's fees for funding. I don't know how many of them actually actualized, but those are newer laws. Is that correct? I know a lot of the SEC laws obviously got, stricter.
Right. I mean, they're more newer interpretations. Over the last 3 or 4 decades, this has really gotten to the point where the SEC issues their advisory letters, and they say no to this a lot, or the court decisions are coming down this way. So something that was okay some years ago, there's a famous case involving Paul Anka, the singer, where he was involved in this in 1990 or so, and it was okay for him, I think, I think what he did is he made some introductions and sort of got out of the way, and then he said that was okay. But the interpretation of that decision has basically been overturned. So it is the case that in the last few years, or 10 years, or several years, some time period, that this got much more strict, than it had been.
But for example, if I'm making introductions to people, as long as I'm not taking, there's no harm in connecting people. Is that correct?
Yeah, I mean, if you're not paying a finder's fee, you can sort of be introduced. That seems okay. But again, this is such a unforgiving area of the law that my advice is always to talk to an attorney about your specific factual situation.
Yeah, interesting. Okay, because people are sending me pitch decks all the time. And if I think of someone who could be a good fit as an investor, I'll forward it on and make the introduction. And, I don't take anything for it. It's just kind of a...
That sounds very benign.
That's fine. Okay, perfect. Okay, amazing. Let's see here. So actually, one more big topic, copyright, because this one gets a little gray and confusing, myself included. So talk to us about, what do early stage entrepreneurs need to be aware of from a copyright standpoint, and what are investors looking for copyright protection?
Right. So copyright is basically a way for artists or creators to protect their visual works, or in classic case, of course, or a book or a poem, but there are more things that are more relevant to a business, such as the layout of your website, for example, certain features of your website, how it looks. You have a copyright from common law, basically the minute you affix a work to a tangible medium or something like that. But there are benefits to filing for federal protection. It doesn't cost a lot at all, and it's probably a good idea to do. Protecting images, or people protect lines of software code, for example. Those are protectable by copyright. The program may be patent, maybe also be copyright. There's different forms of overlapping IP. But you do want to think, if you have certain, jewelry, people file copyright applications on, or they file design patents on that. There's different protections, but if you have something that you think is protectable by copyright, that's a creative work, you want to talk to an attorney to see if it makes sense for you to file some copyright applications on it. Costs are very low, as I mentioned. The investors will look for this, especially if this sort of images or these the way your website looks is sort of a real benefit to your business. They might want to see that you have some copyright applications on file and so forth. It's maybe not. It's very common, of course, to file a copyright application. It may not be quite as important in some contexts as a patent or a trademark application, but it's still a good idea to keep your mind around and understand if you should do it or not.
Yeah, that makes sense. I think on the flip side of that too is using other people's images. Even if you think you have permission, or you have, let's say you have an influencer and they're quote unquote endorsing your product or something, and then you just take one of their images and put it up on your website. I've seen that happen where all of a sudden that person comes back and you're getting sued for their agent is then suing you for putting their image, without permission on the website. So I think on the flip side, you just have to be really careful, right, of using other people's assets like that.
Yeah, if you're taking an image, obviously there are stock images like Shutterstock that you can have a license with them and get images for free. But if you're taking images from another website, and they're aggressive about protecting your IP, you're going to get hit with a cease and desist. Hopefully, they'll let you go away after the cease and desist. But as I said, they sometimes sue. So it's really something to be very careful with, and just to not take these images without permission. A lot of times you can get a license for an image and so forth, but sometimes you can't, and so you should consider other avenues.
Got it. Okay, last thing, resource allocation. Obviously, startups rarely have unlimited funds. And this stuff is super important. It can be costly. What advice do you have or thoughts do you have on resource allocation for IP protection and legal?
Right. I mean, this goes back to what you should be thinking about right from the jump, even before scaling up your business, because an IP attorney can work with you as to, okay, where are the deadlines here for the different forms of protection? What forms of protection do you have available? What are the deadlines? What can afford to wait a little bit? What can? So, for example, if you have a patentable invention, that may not be able to wait if you want to come out and publicly disclose your invention or your product. So you may have to file on that early. As opposed to a trademark application where maybe you don't have to file right away. Of course, it's a good idea to, because you make other people aware of it, but that might be able to wait a little. But what shouldn't wait is, as we've discussed, a due diligence on your branding and trademarks to make sure you're not infringing other people's works. But generally, patent deadlines are more unforgiving than other types of deadlines. Copyright, as I said, you have sort of a common law copyright from the jump. You don't really there's usually not this time crunch to file as there is in patents, and same for trademarks. So for resource allocation, it's really based on deadlines, and it's based on what you have the ability to file on early and what can afford to wait. And then, just beyond the scope of today's podcast, but if you have some sort of a website and you're taking personal information from people, you want to get a privacy policy on pretty quickly, and you want to get terms of use. Potential investors will look at these also because they want to see that their liability is limited because you've protected yourself in these ways too. So I would say patents, privacy policy, terms of use, try to get those up right from the jump, and then a due diligence on the trademarks, and then certain filing strategies can proceed from there.
Got it. Okay. Super helpful. Tell us a little bit more about your firm. Again, most people listening to this podcast are kind of pre-seed, possibly pre-revenue or seed stage. What size companies do you work with? Like, how do you work with them if they're really early stage? Do you do like an initial consultation? Like, what does that look like?
Sure. We work with extremely large companies, multinational companies, and we work with very small companies and startups, and we work with individual inventors. So we run the gamut. It's a good idea, as I said, to talk to somebody like me early on. And what I do is I offer a consultation. I'll get on the phone with you for a half hour, an hour, or even more sometime. We'll just sort of go through what you have, and what forms of IP you may want to start to think about. And then I give you some options for proceeding. And then I say, well, if you want to go further, let's sign an engagement letter. I'll tell you my rates, and then we'll proceed from there. But I always give like an initial call or consultation without charging, which potential clients and startups seem to appreciate, because the choice of an attorney is a particular one. It's yours, and you should be comfortable with your attorney. And I want to make people comfortable that I can help them with their issues, and that I'm a fair dealer, so to speak.
Mm-hmm. That's amazing. Yeah, that is a great offering, to be able to just get on the phone and talk to someone and kind of get their perspective ahead of time is super helpful. Anything else that you can think of that we didn't cover that's kind of helpful for people at this stage, going out to pitch investors, looking for funding?
What I would say is, and I'll just stress a point we did cover, which is please think about these issues early. You don't want to get down the road and find that you're on the barrel end of an infringement suit or a cease and desist or something like that. The allocation of resources is something that you can decide early on and come up with a plan that makes sense, and then proceed from there. But that's really what I want to stress from this is think about the issues, come up with a plan, make yourself more attractive to investors, lock down your IP in stages if you need to, but think about it early so that you're not caught off guard later.
Yeah, great advice. And I think also that really needs to be part of your due diligence package with investors. Like, here's who I'm working with on our IP. Here's, the game plan for it. Even if you don't have all the bells and whistles around it, here's, like you said, here's, how we're phasing it in, or whatever the plan is. Just showing that you've thought through it is super important. And especially if you do have patents, if you do have trademarks, having all that information available in a light format if they have not signed an NDA, and then in a more in-depth format, if they have signed an NDA. So I think that's really great advice. Amazing. Where, Ray, can people connect with you and learn more about your firm and get in touch with you?
Sure. They can go to dipernalaw.com. Or they can send me a LinkedIn, Raymond DiPerna at DiPerna Law, and I'm happy to connect with anyone. I'm happy to speak to anyone, and if you have any questions or so forth, just give me a ring, send me an email, and I'm happy to speak to people that way.
Amazing. Okay, yeah, we'll put those links down in the show notes. Thank you so much. So much good information. I definitely learned some stuff. I love all of this stuff. It's so fascinating and fun, and also can be intimidating because it's complex. So, find an attorney. As Ray said, don't wait. Get a grasp on this stuff as early as possible to save some headaches down the road. So thank you so much, Ray. So good to connect with you, and we'll talk to you soon.
Thanks so much, Taylor. Thanks for having me. I appreciate it. Talk to you soon.